On behalf of our chairman, Bambos Ioannides, our partners from Ioannides Demetriou and Nobel Trust, we warmly welcome you to our seminar this afternoon. The seminar, as you can see, is entitled Recent Developments in EU Tax Law, Taxpayers' Rights and the Impact on Cyprus. I'm sure this gentleman needs no introduction. Correct? I'm sure you all know that he invented the lightning rod and bifocal lenses. Some of his lesser-known achievements are that he drafted the American Declaration of Independence along with Jefferson. He single-handedly drafted the American Constitution, and he negotiated the Treaty of Paris, which ended the American War of Independence. And his name is on the $100 bill. And he said the following when talking to a French scientist. France was at that time in the throes of their own revolution. He said, "Our new constitution is now established. Everything seems to promise it will be durable. But in this world, nothing is certain except death and taxes, and hence the connection." This is why we're all here today, because tax is indeed one of life's certainties. Leaving the computations and the practice aside, however, we believe that tax is essentially a legal issue. Decisions of the Department of Taxation are what are termed to be executive administrative acts, and they're within the primary jurisdiction of the administrative court. The validity of circulars issued by the tax office may be challenged if they're ultra vires to the law, or if they infringe the Constitution, or if they do not display the correct interpretation of the law itself. Additionally, taxpayers' rights have to be protected, and they can be the subject of judicial protection. To give us some important insights into the above matters, as well as recent and future developments, we're very, very proud and pleased to present to you two excellent speakers. Professor Philip Baker, King's Counsel, OBE. On your chairs you will see their full resume. I won't read it out, but Professor Baker is a leading authority on tax law with particular reference to taxpayers' rights, and he has represented governments, and he has a rich jurisprudential history in the European Court of Justice. Professor Christiana Panayi, she's the primary supplier of exotic fruits to our office. But she also, fortunately for her, has a day job, which is rather more rewarding. She's a professor of international tax and EU tax at Queen Mary College of the University of London. We will hear our two speeches, and they will be followed by a question and answer session that will be moderated by Naya Morphy, who I'm sure you know, who is the managing director of Nobel Trust. So on behalf of us all, I'll especially, as I said previously, our chairman, Bambos Ioannides, who needs no introduction, I'm sure, and the partners of Nobel and ID Law, I would like to welcome our first speaker, Professor Philip Baker, to the stand. Thank you very much. One last point, I've been told to tell everybody that this is being recorded. I'm sure that's for GDPR, but also, because it's being recorded, you all have to be on your very best behavior. Thank you. We'll go through.
Marvelous.
think your first one is here.
Super, and I'll just put a clock up so that I know how much time there is. Well, good evening, everybody, and thank you very, very much indeed for the introduction, Andrew, particularly on your name day, and for the invitation to come back to Cyprus. I've been remembering that I think the first time I came to Cyprus was for a conference in about 1992, I think, actually, in a hotel in Limassol, which in those days was outside of the town, and now it's right in the center of the town because of all the growth there. So thank you very much indeed to Nobel Trust and to ID Law for the invitation here. I've been told that you are very interested in the protection of taxpayers' rights, which is one of my favorite subjects, but also particularly interested in exchange of information and on beneficial ownership registers. So I'm going to try in the time available to cover quite a lot. And what I will say is, anybody who'd like copies of the slides, you can have them afterwards, so you don't need to sort of take notes or whatever. And I'm going to go through quite a lot quite quickly. I'm going to talk about the protection of taxpayers' rights and the different levels of protection, and then introduce the European Convention on Human Rights and also the Charter of Fundamental Rights of the European Union. I'm going to say a little bit about big data and tax administration, and then focus in on data protection rights particularly, and then the two specialist areas, AEOI, automatic exchange of information, CRS, FATCA, the risks involved, the possible challenges, and then really end up with public beneficial ownership registers, the Sovim case a year ago, and where we are in terms of registers, and then some concluding comments. There's quite a lot in the time available there. So let me go straight on to the protection of taxpayers' rights. We talk here very much about human rights and taxation. And for example, I teach a course in Oxford on human rights and taxation, and I think there's immediately one point that people sometimes ask, well, what's human rights got to do with taxation? Human rights is about extrajudicial murders, it's about torture, it's about things like that. But of course, human rights is a much more general concept. Human rights defines generally the limits to how governments can treat their residents, their citizens, anyone's within the scope of their power. So it's much more general than just the sharp end, the torture and issues like that. It concerns the relationship with the government. And if you think about it just for a moment, you realize that for most people, the tax authorities are the part of government with which they have the greatest number of dealings. I mean, if I think about myself, every time I go through Heathrow, I have to show my passport to a government official. It takes a matter of seconds, hopefully, usually. If I drive too fast in my car, which I do from time to time, I have an interaction with a government official in the form of either a policeman or a camera. But that's probably the limit of my contact with government officials. On the other hand, every 3 months, I provide to the UK Revenue details of my income and expenditure for VAT purposes, which I wouldn't want to show to my kids or my wife. But I provide that information to the government. So for most people, the greatest contact is with the tax authorities. And so human rights and taxation are natural partners, protecting people in that relationship. Also, as we've seen over the years, we have what I refer to as the Al Capone syndrome. More and more powers being given to tax authorities. It wasn't the FBI that eventually came for Al Capone, it was the IRS. Why? Because the IRS had more power than the FBI to investigate him and to eventually imprison him. And with that increased power is an increase in the need for safeguards, and that's where human rights comes in particular. I think I'm going to jump this question of discussion of the theory of human rights and just give you some very quick examples just to sort of trigger the brain thinking about taxpayers' rights, what are the areas that we're concerned with here? There are things like confidentiality of personal data. We give personal data to the tax authorities. Are they going to protect that data? Something we're going to come back to. When you're in an audit, what is the conduct that the tax authorities can exercise? If they've decided this may be a criminal matter, do they have to give you a warning? If you challenge the revenue authority before the courts, what are the fair trial rights? When they come to enforce taxes, what are the limits to the enforcement of taxes? Obviously, criminal prosecutions engage human rights. And then there's the actual tax law themselves. Issues like, for example, are retroactive tax laws? Are they consistent with human rights? Just a little note here. We talk about human rights, but of course, companies should not be excluded. Some of you may be thinking, well, this is fascinating, but I work for a bank. Does a bank have human rights? The answer is yes, they do. Some rights obviously are not applicable to companies. The right to life. You can't imagine a company in liquidation saying, you can't liquidate me because I have the right to life. But on the other hand, things like the right to a fair trial. A company has exactly the same rights, the right to a fair trial. The right to property. It's effectively on behalf of those behind the company. The right to privacy. Freedom of religion. Can you say, I am an honest, God-fearing, limited liability bank? Well, yes, if you think about it, many churches, many mosques, many synagogues, they are all set up in the form of a company that owns the property, and so the freedom of religion, freedom of conscience, that applies as well. These rights are protected in many countries at many different levels. The tax law itself will often protect rights, the rights to take an appeal against a tax liability. Administrative law, you mentioned earlier, George, administrative appeals in Cyprus. Constitutional law will contain, in some cases, rules about taxation. And then a growing number of countries have specific laws on taxpayers' rights, rules like taxpayers' charters or a taxpayer's bill of rights. But then we start going internationally, and we ask whether there are rules of international law. For example, the rule of non-discrimination, which exists in international law, or the rules in double tax treaties, the non-discrimination article in tax treaties. Limited scope, but sometimes that kicks in to protect cross-border scenarios under a tax treaty. And then we come towards human rights instruments. We've got some international instruments that apply worldwide, like the International Covenant on Civil and Political Rights. But then, and this is really focusing in on our topic for today, you have regional laws that protect taxpayers' rights. And in the EU and the EEA, we have the European Convention, and we also have the Charter of Fundamental Rights. For those of you who are still members of the European Union, I, of course, have Brexited, or rather, I have been Brexited. It wasn't my choice there. But during this period, while the United Kingdom is temporarily outside the EU, we'll be back there. During that period, you enjoy these rights. We don't enjoy the Charter of Fundamental Rights. I suspect that everybody here is expert on the Charter and the ECHR, but just a little bit of a reminder, the Convention of Human Rights is almost 75 years old. It was drafted in the aftermath of the Second World War. It was concluded at Rome in 1950. It's not an EU measure, it's a Council of Europe measure. So it covers a much wider range of countries from, well, I used to say from Cork in the west to Vladivostok in the east. Now I have to say from Cork in the west to Belarus in the east, and from the Arctic Circle down to Larnaca in the south. It's general law for all of the Council of Europe countries. There are 46 member countries. It's supervised by the European Court of Human Rights in Strasbourg, and In the past, I've been involved in some of the cases that have gone from the UK to Strasbourg because every country recognizes the right of individual petition. That's the right of citizens of the countries to take a case to Strasbourg. And amazingly enough, there's a large tax jurisprudence of the European Court. There's over 1,000 cases since the early 1980s. There was a case decided just yesterday involving the Ukraine and gambling tax. If there's time, I might mention that very briefly. So the ECHR, one of the limits on it, though, is that you can't go straight to the ECHR. You've got to go through your domestic courts first and exhaust domestic remedies. So if you've got an issue under the ECHR in Cyprus, you have to litigate in Cyprus first. And then if you fail, then you can take the case up to the ECHR, and the ECHR can give you a remedy which is sometimes referred to as just satisfaction. That heading is wrong actually there. It should say Introduction to the Charter of Fundamental Rights, the CFR. The CFR, Charter of Fundamental Rights, is an EU instrument. It was declared in the year 2000, came into force several years later. It's part of the changes that resulted in the Treaty of Lisbon. It's based very much on the European Convention, but it has more extensive rights. It's broader and contains more rights than you will find in the European Convention. One particular point about it is that it's limited for member states only to when the member states are implementing union law, that phrase that's underlined there. So you can't use the Charter to challenge, say, Cyprus income tax, because Cyprus income tax is purely domestic Cyprus legislation. But you can use it to challenge VAT, because VAT is a European tax, and Cyprus is implementing the VAT directives. So when you're implementing EU law, then you come within the scope of the Charter of Fundamental Rights. You can look this yourself. There are limits on the rights in the Charter, and this little point in the middle there, because the Charter is based upon the Convention and has similar wording, where there's established jurisprudence from Strasbourg, at least that's partly followed by the court in Luxembourg. So there's a tendency to also look to what has been decided in Strasbourg. One big difference, though, about the Court of Justice in Luxembourg is that you don't have to exhaust domestic remedies. You can get a Cypriot court to make a reference under the Charter to Luxembourg without having to go all the way up to the Supreme Court here. And that's making the court in Luxembourg a more attractive route for taxpayers, corporate service providers, law groups that want to challenge under the Charter. They can do it more easily through the Charter and the CJEU route than going through Strasbourg there. Just a couple of examples. I'll just take two quick examples of recent ECHR. These are Strasbourg cases on tax law. Just two recent cases. First one, LB and Hungary, naming and shaming. Hungary has a law that allows them to name and shame major tax defaulters. And to be a major tax defaulter, you have to owe 28,000 euros or more. So it's not a very major default. If you haven't paid 28,000 in tax within 6 months, they can put your name on a list of defaulters. Your name and your address and your tax identification number. Well, LB didn't pay his taxes. He was subject to a penalty which brought him within the scope of the convention, and he was very upset that his address, in particular, was on this list of defaulters. So he took the case to Strasbourg and he said, this is an infringement of Article 8, the right to privacy. Why should everyone know that I haven't paid my taxes and my address? Well, he was partly successful. The court in Strasbourg said, naming and shaming, if the government has decided that that is a way of putting pressure on collection of taxes, that is within the state's margin of discretion. But giving the address goes beyond that. Giving the address of the person so that their neighbors know, that is disproportionate. And that was a breach of Article 8. So I imagine Hungary, and there's about 10 other countries in Europe that had similar rules. They will have had to change their rules. And sometimes decisions from the court in Strasbourg have an effect right the way across Council of Europe countries, that there has to be a change in the rules of the country, and those that included the address, they had to remove that as well. Second case I'm going to mention very briefly is a case called Demetriou and the Netherlands, and this is one of a number of cases about the principle of self-incrimination, the Latin nemo tenetur. Can you be forced to give evidence to the tax authorities, which may then lead to them prosecuting you or imposing a penalty? Can you be forced to self-incriminate? Now, if you think about that for a moment, we generally, in virtually all legal systems, protect people against self-incrimination. You can't be interrogated and made to confess. But on the other hand, in tax matters, typically the taxpayer knows all the information. So if the taxpayer says, I'm not going to answer your questions, that could lead me open to a penalty, tax investigations will never get anywhere. And there's been a number of cases on this, and broadly a line is drawn between handing over existing documentation and answering questions or creating new documentary evidence. If you have an existing document, like a bank statement, which already exists, requiring that to be handed over is not a breach of the principle of self-incrimination. Because if you think about it, the tax authorities could get a search warrant, they could search your house, they could find the document, they could get hold of it, or they could get it from the bank there. On the other hand, answering questions and creating new documents, that would be self-incrimination. And so a tax authority cannot say to the taxpayer, tell us how you avoided tax. And if the taxpayer says, no, I'm not going to tell you, the tax authority cannot impose a penalty. They have to respect the principle of non-self-incrimination. That's a case just about a year ago, a case called Demetriou in Netherlands, that confirmed that. Those were just two examples, fairly randomly picked, of cases from the Court of Human Rights. I'll talk about some CJEU cases if I have time a little bit later. I've got a section of the talk about tax administration and big data. I'll go through this quite quickly because you all know tax administrations are hugely data-driven organizations. They always have been. We've always had to supply a lot of personal information to tax authorities, financial information, and personal information, your address, how many children you have, to what organizations are you making donations. Somebody looking at my tax return would not take a lot of time to work out my political allegiances, what my interests are, my religion. You could work that out very quickly from my tax return. So there's a huge amount of personal and very sensitive data, including information about donations to political parties. Technological advances, big data, offer tremendous scope for tax administrations. There can be simplified submission of tax returns. I don't know what the position is in Cyprus. In the UK, it's now becoming virtually impossible not to submit returns electronically. Virtually everything has to be done electronically, and we're moving towards pre-populated returns. I don't know whether that's being looked at in Cyprus, but pre-populated returns are where the tax authority has so much information about you, from your employer, from the banks, from companies you invested in, that they send you the tax returns saying, we think this is what you earned in the year. Is it correct? And if it's correct, you simply tick it and send it back and pay the money. And there are countries in Northern Europe where that is now the system, where you get, Sweden, for example, has pre-populated returns. They have so much information that they tell the taxpayer what they think you owe rather than the other way around. You can provide targeted advice, and then there's the whole use of data analytics, profiling taxpayers, auditing those who are identified, identifying protection frauds. But there are big dangers in the gathering of so much data by the tax authorities. And before I identify some of those dangers, we've seen relatively close to here an example of these dangers just a couple of years ago in Bulgaria. In Bulgaria, in July 2019, the Bulgarian National Revenue Service was hacked, and the personal data of 5 million individuals, and Bulgaria only has 7 million people, 5 million people's data was hacked and apparently was then available on the dark web. The information included information that had been received from other countries under CRS. And I'm going to talk about CRS and the dangers. That's where the bankers in the audience get very nervous there. Some of the data that was hacked had been received under CRS. Strangely enough, the Bulgarian revenue received just a fairly small fine, and for a short time they were suspended for an exchange of information. I suspect they're back in the system. But 5 million adults in Bulgaria, the entire adult population, now know that their personal data has been leaked and is available on the dark web. And this is just some of the many concerns about the use of big data. What are the problems? Errors in the information that is being transferred. As you know, rubbish in, rubbish out. If you've got bad information when you took on your client at the bank, the information that you will be supplying about their residence or whatever will be incorrect. Wrong taxpayer. I've had a couple of matters in practice in chambers where my clients received a letter from the revenue saying, we have information about you, that you have a bank account in the US, which you don't appear to have declared. And we start asking about that, and it turns out that it wasn't a bank account, it was a pension arrangement, which hadn't yet been tapped into because the individual wasn't a pensioner, or the information related to the wrong person. It wasn't Philip Baker, 3 Woodside, it's Philip Baker, 3 Wood Grove, or something like that. So much of the information is wrong. We have the problem of possible leaks, the hacking in Bulgaria. Small-scale leaks might very well be linked to the corruption in the Revenue Authority, but then there's always this danger of huge data loss. And particularly as we gather together in the Revenue Authorities more and more big data, we are making our revenue authorities a very attractive target. If I happened to be a dictator of a large country, and I knew that within the OECD there has been gathering together of data about all overseas bank accounts held by anyone within the scope of the common reporting system, I'd want that data. And I'd be saying to my officials or to my hackers, hack the data. But actually the answer would come back, you don't need to. Our country is already part of that system. we can get this data as it relates to members of our country. So it's made tax authorities and the CRS system a very attractive target, and there's the danger the information will be misused. And there are the concerns not just about governments that are presently benign, but governments that are malign, or governments that are benign at the moment, but may become malign in the future. We have been exchanging data with Russia, in some cases, until after the Russian invasion of Ukraine. When Russia invaded Ukraine, no doubt through some of the tax offices that in the areas that they invaded, they had access to data about Ukrainians and their tax affairs that had already been exchanged. So there's a real danger of non-benign governments getting access to that there. There's a whole question about collateral damage. One of the issues I'll talk about towards the end is the issue of FATCA and accidental Americans. Some of the unhappiest people in the world are Americans living outside of the US. Actually, some of the most unhappy people are Americans living in the US. I mean, the prospect of a Trump presidency must make anybody want to leave the country. If I were giving a tip to people in Cyprus, look to attract your Americans in the next couple of years, because the number of Americans who are going to want to leave America in the next couple of years is huge, particularly if Trump is re-elected. Virtually every American I've spoken to recently is talking about, do we want to stay in America? Or one of them I spoke to said, I'm not too worried. I've got a little lodge in the Blue Hills of Virginia. I've stocked it with enough food and guns for 4 years, and I'm going to go there if there's a Trump presidency. But accidental Americans, people who happen to be born in America, the difficulty they have in opening up bank accounts, because as soon as it's said, you were born in Chicago, oh, you're an American citizen, are you compliant? Many banks won't take on Americans, and that's not really linked to big data, but it's a consequence of FATCA that we'll be talking to. So I spoke a little bit about the background of the big data. Let me quite quickly talk about data protection rights. And this is really for the lawyers in the room. The non-lawyers, you can check your emails while they're going on actually there. There are a number of legal protections for data protection. Under the European Convention, it derives from the right to privacy. The European Convention is 1950s, it's before big data, but it talks about the right to respect for private and family life, and from that we have a protection of data within the European Convention. Within the EU, data protection is so central, so important, that it actually features in the 2 treaties establishing the European Union. The Treaty on the Functioning of the European Union and the Treaty on the European Union make explicit reference to data protection. There. Under the Charter of Fundamental Rights, we have Article 7, which is the parallel to Article 8 of the European Convention. It's the right to privacy. And then we have Article 8, a specific protection of personal data. So Charter has a specific data protection there. And that's implemented into EU law, as you will know, through the GDPR, through the General Data Protection Regulation. Very, very quickly, a little overview of this. The GDPR protects the fundamental rights and freedoms of natural persons, and in particular, it sets down principles for all processing of personal data. And I'm certain any compliance officer here probably has this engraved on your heart there. Any personal data has to be processed lawfully, fairly, and transparently. It has to be collected for a specific purpose, the purpose limitation rule. Any collection of data, you have to identify the purpose and only collect the data for that particular purpose. The collection of data has to be minimized, limited to what is necessary, obviously there have to be measures for checking the accuracy of data and correcting inaccurate data. The storage has to be for no longer than is necessary, and you have to have appropriate security to protect against hacking. These are all the principles that deal with data protection. And additional rights that GDPR gives: anyone whose data is processed has a right to know about that processing. They have a right to access that data, a right to rectify the data. If your bank tells you, which they should do, we are sending your data under the CRS system, you have a right to see that data and to rectify it. I have a bank account in France because I have a house in France. Every year they tell me how much information they are going to give to the UK revenue and how much interest on my bank account they're going to tell the UK revenue. Just as a matter of interest, the figure that they tell me is never the same as the figure I put on my tax return. I always make certain that my tax return has a higher figure so that the UK revenue can look at the information and say, oh, he's declared even more interest. I would never declare yes, I always declare more. So there are rights to rectify the data. There are the possibility of restricting some of these rights, including in taxation matters. So governments can restrict data protection rights for tax, but if they do so, they must do so with very specific legislative authority. The government cannot simply say, oh, data protection doesn't apply to the revenue. It does, but there are exceptions possible, but they've got to meet these large number of requirements that are set out on the slide. Very briefly, just a couple of cases from Luxembourg now. You saw a couple of cases from Strasbourg, a couple of cases from Luxembourg on tax and data protection. The first case, I will give a reward to anyone who can pronounce the name of this case. Satakuna Mariaporsi Oi. It's a Finnish company case. I've never learned how to pronounce it there. Finland is one of those North European countries where the data about how much tax everybody pays is public. There's a public register, and you can go on the register and you can find out how much tax your neighbor paid last year, how much they're due to pay this year. I've always assumed it's sort of because of the sauna society. We all go naked into the sauna. Everyone can see what you have. Equally, they can see what you owe in terms of taxes. Anyway, this particular unpronounceable company took that data and they produced a number of kind of magazines based, for example, on particular areas of the country. So if you happen to live in Helsinki, you could buy the Helsinki directory, and before you went to dinner with some friends, you'd check up with the friends how much they'd paid in tax last year. You know, do we take a bottle of champagne or do we take a bottle of house wine? Depends on how much tax they paid last year. Question was this acceptable use of the data? The data was in the public domain, but this was using that public data to provide information that people could use to check up how much everybody was paying. A case came through to the European Court, and the European Court said, data protection even applies to public information. Even though this was in the public domain, taking that and republishing it, packaging it, that was processing of data. It was without the consent of the data parties, and therefore it was potentially a breach of data protection. But there could be a justification based on journalism. If this public data was being used to identify potential fraudsters to make comments about the fact that the legal profession seemed to be paying less tax this year than last year, then there was a journalistic exception. And so the case was sent back to the National Court in Finland to say, is this just the processing of data for prurient interest, or is it journalism? And I can tell you that the Finnish court decided this is not journalism. This was just making data available for those who wanted to see what are my neighbors paying in tax. And there's a subsequent case in the court in Strasbourg about this. But you can see how even public available data is still protected by the GDPR. A case the other way is a case involving Latvia, where a website provider advertised second-hand cars for sale. And the tax authorities said, we would like you to provide us with a list of all of the people selling second-hand cars, because we want to check, are they declaring profit on the sale of the cars? So the tax authorities wanted the data about the sellers of the cars available. That was held not to be breach of the GDPR, because the data was necessary for the tax authority, and they were asking about very specific periods of time, not asking about every single car to be constantly provided to them. So they case the other way on data protection. Right, now, about the last 15 minutes or so, if that's okay, I think we agreed we started about 15 minutes late, so I don't want to eat into Christiana's time. I know you've all really come to listen to Christiana rather than me. I'm just the warm-up act. It's pretty warm in the room, actually, but I'm just the joker who liked before Christiana. Let's come on to the two topics I wanted to focus on. AEOI and beneficial ownership registers there. AEOI, Automatic Exchange of Information, is not new. It's existed for a long time under tax treaties, under tax information agreements, and there's a multilateral convention which has 147 countries that have agreed to exchange information automatically. But, as you will probably know, particularly if you work in a bank, the big growth has been in the last 20 years. And it came from the US. This is something that started in the US, and then the rest of the world jumped on it. It was the revelations in the 2000s that there were US citizens with undisclosed bank accounts, particularly in Switzerland. And some of the Swiss banks, as you know, have paid large penalties. Some of them have actually gone out of business because of their involvement with US persons who had undisclosed bank accounts. That led the US in Congress 13 years ago to introduce FATCA, the Foreign Account Tax Compliance Act, which is a one-way information street. One way in that the US doesn't provide information out. It's all information in to the US. The US said any foreign financial institution that has US citizens as their clients must provide us with information about the accounts held by their US citizens. The Swiss banks said, we can't do that. We cannot provide information to a foreign government. It will be a breach of Swiss law. Okay, said the Americans, we'll enter into an agreement with the Swiss government. You give the information to the Swiss government, and they will give it to us. So IGAs, intergovernmental agreements, were entered into as a way of getting around what would otherwise have been bank secrecy restrictions. Once the Americans were having IGAs with countries like Switzerland and then with countries like the UK dependent territories, the UK wanted to get onto this. And the UK said, well, if Jersey and Guernsey are having agreements with America, we want to have agreements with us as well. And then France and Germany and Italy and Spain, they also decided to get onto the bandwagon. And the bandwagon moved very, very quickly, and it was picked up by the OECD. And you'll know between 2009 and 2014, within the scope of the OECD, they developed the CRS system, the Common Reporting Standard System, which is effectively a two-way FATCA, a bilateral FATCA, based upon the ideas, the concepts in FATCA, but broadened to cover a much larger group of countries there. The CRS standard requires financial institutions to identify accounts, which is not just bank accounts, but also trust relationships, investment accounts, to identify those where the account, the ultimate beneficial owner, is in another country, to supply the information to the tax authorities, and then for that to be exchanged. It's a massive exchange of information about a range of accounts. And of course, if anything's happening in the OECD, the EU will go immediately after it and often go a step further. And in the case of the EU, the Directive on Administrative Cooperation was amended in 2014 to introduce an EU-wide system of exchange of information under DAC 2. And I suspect many of you, particularly if you're in banks or in compliance there, you are very well aware of those systems. So AEOI takes place either under DAC 2 or under FATCA, under tax information agreements. Just a couple of figures there. 2019, when the system started, the OECD reckoned that under CRS, information on 47 million accounts was exchanged. By the year afterwards, the information was on 75 million accounts and information about 9 trillion euros of assets was exchanged involving 102 jurisdictions. I haven't been able to find the figures for 2023, but clearly it's gone up exponentially since then. This is a huge amount of data going through the CRS system, operated through the OECD, and then passed on to other countries there. And the information, as you'll know, includes taxpayers' names, TIN numbers, account details, the income and the gains on the accounts balances, tremendous amount of financial information, as well as the identity of the taxpayers concerned. Now, what about data protection? We've got huge amounts of information going from country to country, some of it economic, financial, some of it personal information. What are the protections? Well, the GDPR, back to the GDPR rules, actually limit cross-border exchanges to 3 very specific situations. There are only 3 circumstances where GDPR authorizes the cross-border transmission of information. Firstly, where there's an adequacy decision. The European Commission can assess a country, foreign country, outside the EU, and determine whether that country has an adequate level of data protection equivalent to that within Europe. So there can be an adequacy decision. At the moment, there are only, about 12 adequacy decisions. You'll be pleased to know Andorra is on the list, but also Argentina, Canada only to a limited extent, the Faroe Islands, Guernsey, Israel, the Isle of Man, Japan, Jersey, New Zealand, Republic of Korea, Switzerland, the UK. Of course, the UK was within the system when we were pre-Brexit. Now we covered the US, but only to a limited extent within the US. Only commercial organizations that participate in the special framework, and Uruguay. That's the only Latin American country. So there are not very many, Argentina is also Latin America, there are not that many adequacy decisions. Secondly, there can be a transfer if there are adequate safeguards. The data controller has to ensure that the recipient provides adequate safeguards, but that means that the data owner has to be protected in the country of the recipient, and there are a number of conditions to that before that is available, including that the data owner is aware of this exchange. Finally, there is a very limited derogation, essentially for short-term emergency situations. In short-term situations, a transfer that is not repetitive, in other words, not a regular transfer, can be covered under this third situation. Clearly, CRS regular exchanges cannot cover under this non-repetitive. So really, we've only got the possibility of exchanging information with the small number of countries for which there's an adequacy decision, and otherwise there have to be those appropriate safeguards. The whole issue of CRS, DAC2, FATCA, and data protection is a time bomb waiting to explode. Right from the time that this was first introduced, virtually every data protection authority within Europe warned that these systems are not compatible with data protection, with those rules that I've explained to you about the limited circumstances of cross-border exchange. This is the opinion of the European Data Protection Supervisor, who is an EU-level supervisor. The EDPS was never consulted when these systems were introduced. They consider that there are bigger risks in cross-border exchange of information where there is more than one jurisdiction involved. It implies greater efforts need to be made to protect against data protection. The issue of data protection has been almost completely ignored in connection with CRS. There was the old Article 29 Data Protection Working Party, now the European Data Protection Board. They said without an appropriate legal basis, the obligations imposed on European FFIs, so the banks that are here, would result in unlawful processing of personal data. They carried on to say the practical rollout of CRS based on existing FATCA IT lacks adequate data protection safeguards. And then we've had a number of cases in Europe, not in the tax context, but in other contexts, where cross-border exchange of data has been thrown down by the European Court. Digital Rights Ireland concerned the retention of data and the transmission of data by telephone companies. That was found to be a breach of the GDPR, the pre-GDPR rules. Schrems, transfer of Facebook data to the US, a breach of the GDPR rules there. Tele2 Sverige, general data retention for electrical data services, a breach of the GDPR rules. And then the Schrems 2 case there. A series of cases from Luxembourg where again and again the European Court has said this gathering of large amounts of data and its exchange across country breaches GDPR. Why haven't we yet had a challenge to tax? Why haven't we yet had a tax case before the European Court? Well, there have been a couple of attempts to bring a case based upon the position of these accidental Americans. So far, none of those cases have gone beyond the first level there. But there's a case starting in the UK, a case called Jenny's case, which is being set up in order to test FATCA before the European Court of Justice. It's only a matter of time before a case comes to the European Court on automatic exchange of information, and I'd be prepared to bet a certain amount of money, maybe not a lot, but a certain amount of money, on the European Court concluding, as the data protection agencies did, that all of this system of automatic exchange, particularly FATCA, is all unlawful. It all breaches Article 7 and Article 8 there. Very quickly, then, on public beneficial ownership registers, there, here we do have a European court case, and it went against the public registers. You'll probably know the background here. It's not a very long background. 10 years ago, the G8 decided that companies should know who really owns them, who is the UBO, and that should be accessible to tax collectors and law enforcers. And that was implemented originally by the fourth money laundering directive, which said UBO information should be available to competent authorities and financial intelligence units. Okay, very obvious. It should be available to obliged entities, those who have to apply AML, and then it should be available to anyone else who could demonstrate a legitimate interest. That wasn't good enough for the European Parliament. The European Parliament wanted public access. Anyone in the public without a legitimate interest, maybe with an illegitimate interest, could get access to this information. And the fifth money laundering directive did exactly that. It changed that last C to any member of the public, no longer a requirement of legitimate interest. Well, as you probably know, that was tested a year ago in the European Court in a case called Sovim. The case partly involved whether exceptions from the access could apply to people who thought they were under particular risk. But essentially in Sovim, there was a direct challenge to the lawfulness of public access to beneficial ownership register. And look what the court said. Paragraph 44, the general public's access to information on beneficial ownership constitutes a serious interference with the fundamental rights enshrined in Articles 7 and 8. We saw Article 7 and 8 before. It cannot be considered that the interference with the rights guaranteed in Articles 7 and 8, which results from the general public's access, is limited to what is strictly necessary. Public access breaches two articles of the Charter, Article 7 and Article 8. It is unlawful to give generalized public access to a beneficial ownership register. It breaches the rights there. What happened as a result of it? Well, a number of countries closed their public registers. I'm delighted to say that one of them was Cyprus. Cyprus, within a matter of days, closed its public access to the beneficial ownership register. But there are a couple of countries that have decided to stick with it and to keep them open. And it's an interesting question how soon the European Commission brings an action against France, for example, for not implementing the Sovim case. Because France is, as the French does, it is breaching European law by continuing to have public access. The UK, of course, is outside the EU, and so we're not governed by that. And so the UK has kept public register of persons of significant control over a company. We've kept that. And as you may know, we are pressurizing at the moment our crown dependencies and overseas territories also to have public registers. And some of them are saying, no, you've got it wrong in the UK. We're not subject to European law, but we are subject to the European Convention on Human Rights, and under that, this would be a breach of rights there. So very quickly, and I'm sorry, Christiana, I've taken, but you've got enough time actually there. Very concludingly, there is a need for balancing privacy and data protection, but should the majority of law-abiding citizens be put at risk in the way that they are being put at risk at the present moment by the gathering of this large data? Are public beneficial ownership registers unlawful in the EU? Yes, they clearly are. There's no question about that. We are now at the point where it can only be lawful to limit access to those with legitimate interests. And final comment, it is only a matter of time before a case gets to the European Court challenging FATCA and CRS. And as I say, I would put my money on the European Court concluding that those systems are in breach of data protection. That's the last thing I wanted to say, and let me pass over now to Christiana.
Hello, everybody. I'd like to thank ID Law and Nobel for organizing this wonderful event. I would also like to thank Philip Baker, who is a good friend and a mentor for almost 20 years, for agreeing to do this seminar together with me. I think that the choice of topics is quite interesting. Philip talked about how basically taxpayers are challenging laws, EU laws, or domestic laws, tax laws, on the basis of human rights. And I'm going to talk about recent developments in EU tax law, and you will see how, in fact, what is happening in the EU is basically the Commission closing in on what it calls aggressive tax planning, which is more or less tax competition. So there's quite, the two topics are, in a way, they're contrary to each other, but they show the kind of era that we are in right now. So basically, the impact of, if the question is, how has EU law, how has EU tax law impacted the Cyprus corporate tax system? Well, as you know, pre-accession, the impact was huge. Cyprus had to change its system, its sort of direct tax system, quite a lot, because it had sort of a lot of ring fencing. It was acting like an offshore center, like most former British colonies were. It had a tax having a reputation, but all of this changed from 2001, 2002, when in anticipation of joining the European Union. So there's a major overhaul of the system. Obviously, the indirect taxation was harmonized because in the European Union, VAT, excise duties, they're all harmonized. As far as direct taxes, and especially corporate taxes, were concerned, there weren't major changes other than removing the ring-fencing effect of just basically giving benefits to non-residents. But Cyprus had to comply and has to comply with general EU law, what we call the acquis communautaire. The question is, what was this acquis communautaire, and has this changed? So initially, what this meant, general EU law, was any EU legislation. As far as taxation is concerned, we had very few tax directives. We had the Parent Subsidy Directive, Interest and Royalties Directive, the Merger Directive. But all of these directives more or less empowering groups, cross-border groups within the European Union to be able to move passive incomes like dividends, interest, to reorganize with less tax impact, with fewer tax burdens. So when Cyprus joined the EU, the system was quite liberal at the time in the EU system. So the focus was very much on removing obstacles to cross-border movement. And that was obvious from the tax legislation, the directives that were in place, but also from the cases that went to the Court of Justice on the basis of fundamental freedoms. Freedom of establishment, free movement of capital. What was happening at the time were a lot of cases where the member state tax rules were being attacked on the basis that they did not comply with the freedoms. There was also the state aid prohibition, has always been there. It's a competition law provision which basically forces, does not allow governments to give state aid to specific actors, and that could be through the tax system. And soft law was quite important back then, it still is today. So soft law, when we talk about soft law, we mean non-legally binding, but which has a lot of political force. So, for example, the Code of Conduct on business taxation, that's quite important. It was and still is. And that's part of the reason why Cyprus had to change its system prior to accession, because of the principles under the Code of Conduct on business taxation, which which basically required Cyprus to dismantle any provision that had a ring-fencing effect, basically giving benefits only to non-residents and lacking substance. So this was sort of how it was when Cyprus first joined. And in fact, there were, apart from obviously adopting VAT and everything that was harmonized, there was very little that was needed in terms of the corporate tax system. So there was no need to have withholding taxes because EU law doesn't require withholding taxes. In fact, EU law, through the Parent Subsidy Directive, requires member states not to impose withholding taxes under certain circumstances. So it was quite a liberal system at the time, in a sense, and that's why perhaps Cyprus' tax system thrived in the early years, because it was aligned with the tax trends in the Union at the time, which was very much about removing obstacles to cross-border movement. However, since then, there's been quite a shift in the mindset in the European Union as far as taxation is concerned. This was partly a result of the financial crisis in 2009, the BEPS project, where there's been a lot of changes and a lot of focus on addressing BEPS, base erosion profit shifting, aggressive tax planning. So we see as far as the tax the EU tax law is concerned, we see a shift in mindset from a more free trade, neoliberal approach to more protectionism and over-regulation. So what Cyprus has to comply with today as an EU member state, what the acquis communautaire is today, is quite different from what it was when it first joined. So we have a lot more tax directives, or I would say amendments to directives, which I've listed here. Most of this focus on anti-abuse provisions. So for example, before 2016, when the ATAD directive was introduced, there was no CFC legislation in Cyprus, and then that had to be introduced, whereas almost 20 years before, there was a case in the Court of Justice where the UK CFC rules were struck down on the basis that were in breach of freedom of establishment. So you can see the clear sort of different focus going from removing anti-abuse provisions that restrict movement to requiring member states to impose anti-abuse provisions. Also, the cases going to the Court of Justice, there's been sort of a shift from the more liberal judgments where very few justifications were accepted. Now the judgments are much more nuanced. The interpretation is much more restrictive. There is sensitivity for protecting the tax base of member states, although having said that doesn't mean that all cases fail. Quite a lot of them go forward, and there's a judgment against the member states, so they need to change the legislation. The state aid prohibition has been very, so that we have very high profile cases where in the tax area, where basically tax authorities in Luxembourg, the Netherlands, Ireland, were giving tax rulings to multinationals, and the Commission started investigations, state aid investigations, and then proceeded to take these cases to the Court of Justice. And I know Philip is involved in some of these cases. Basically what they're saying is that the tax authorities, by giving rulings or advanced pricing agreements, they were basically helping certain multinationals by allowing them to basically pay less taxes. The effective tax rates were much lower than they should have been. So the Commission in these cases that is trying to bring through the back door the arm's length principle, for example, to basically say any tax authority that doesn't follow the arm's length principle and allows multinationals or taxpayers to pay less taxes, that is a state aid prohibition. We haven't really had that many cases go through the Court of Justice to know whether or not this, what the Commission is trying to do is succeeding. I think up until very recently, it looks like the arguments the Commission is using are not winning the cases. The Court doesn't seem to be convinced that you can just say if this doesn't comply with the Armstrong principle, it's a state aid, it's a breach of the state aid prohibition. But we're still waiting for some big cases like Apple case to see what the court decides. And then the fundamental rights, the Charter of Fundamental Rights that Philip talked about, and you can see how those rights are quite important, and they've been used by very resourceful taxpayers to attack EU legislation that doesn't seem to comply with this charter, which is primary law, it's hard law. So in general, there's strong focus on anti-abuse rules, as I said, an increase of exchange of information and cooperation between tax authorities, which creates a huge compliance burden. And it's very interesting to hear from Philip's presentation how actually automatic exchange of information is very problematic and may be in breach of other areas of EU law. The other strong focus that is within what we call EU tax law today is a focus on effective tax rates and not having very low effective tax rates. So the directive of the minimum effective tax rate effectively says that for multinationals, and they've been in scope groups are those that have revenue of 750 million in general, unless the effective tax rate is 15%, then there will be taxation of the constituent entities. I am oversimplifying this. This is a very technical legislation. This was adopted, this was agreed in Council last December, and is going to be, has to be adopted by all member states, including Cyprus, by the end of the year. There will be, as far as Cyprus is concerned, from what I've been told, there will be very few in-scope groups where this would be an issue. Obviously, this could be an issue for Cyprus because the corporate tax rate is lower than 15%. But as it does not catch all companies, it's only for very specific circumstances, for large groups, then the impact is slightly limited. There might be sort of a spillover effect in terms of raising the corporate tax rate anyway, so just to make sure that you're aligned with the 15% and don't have all this extra hassle. But as far as I know, this has not yet been suggested. Now, what seems to be being center ground today is soft law, as far as taxation is concerned. And I've always criticized this tendency, this trend, because soft law means that the Commission provides a communication or an opinion or an action plan, but no member state actually votes on it. And it goes to the Code of Conduct Group, for example, and it's been investigated. But it's not hard law. It's not something that you can take to the Court of Justice and say this is in breach of EU law. But this has begun to be used quite a lot in the tax area, and it's raising a lot of legitimacy concerns. For example, the EU blacklist, so colloquially called, which is the list of non-cooperative tax jurisdictions. This is basically a list which the Code of Conduct Group, they decide twice a year which countries outside of the EU do not comply with EU tax governance criteria. So it doesn't affect member states. So member states are not scrutinized because there's no competence to scrutinize member states on the basis of this list, but they scrutinize third countries. And there can be sanctions as a result of this. So recently, the Code of Conduct Group came out and said, well, okay, we have this blacklist and we have let member states decide how they're going to deal with these jurisdictions, but now we're suggesting defensive measures, and one of which is withholding taxes. So in fact, Cyprus had to introduce, I think last year, withholding taxes for certain types of payments to companies in listed jurisdictions, subject to conditions. So one of these listed jurisdictions is now Russia, since the March of this year. This is quite an intrusion in competence of member states, and it cannot really be challenged, or it should be challenged, but it's very political. We also have a revised Code of Conduct on business taxation, so now this is effective for legislation that is introduced from the 1st of January, I think 2023, so any new legislation must comply with this. And it no longer focuses on ring-fencing legislation, so legislation that provides benefits to non-residents. It also attacks, now there's scope for investigation for general legislation that has the impact of attracting investment and it could lead to double non-taxation. So this is quite a big opening of the code of conduct and the scope of the investigations that member states would be under from now on. And perhaps what is more problematic of all is all these initiatives to tackle aggressive tax planning and all the country-specific recommendations. Philip and I were at a conference last week in Brussels, and he talked about aggressive tax planning and how this is becoming a political concept, more or less, because there is no sort of common legal understanding of what aggressive tax planning is. And in many cases, tackling this vague notion of aggressive tax planning has been linked with funding that member states are getting from the European Union. And Cyprus is a very good example. In its recovery and resilience plan, it was stated that there is a need for tax reform to increase the effectiveness, efficiency, and fairness of the tax system by combating tax evasion and aggressive tax planning practices by multinationals. Now, this sort of bringing together of the two is quite problematic. Tax evasion is illegal. Aggressive tax planning, up until maybe 15 years ago, didn't really exist. So it's more about it used to be called harmful tax planning, perhaps, in the OECD Harmful Tax Acquisition Project. But aggressive tax planning is quite a new concept, and it's very difficult to define. And by sort of linking tax reform, which is a very important part of the sovereignty of member states, with sort of this malleable, vague concept, I find it quite problematic. So the three reform sub-measures that were actually suggested or demanded from Cyprus's Recovery and Resilience Plan, the first is to impose a withholding tax on outbound payments of interest, dividends, and royalties to countries that were in listed jurisdictions in the EU blacklist as a sort of a first milestone. And this has already been done. Also, the change to the corporate tax residency system, as you know, this has already been done as well. So now, apart from the management test, you also have incorporation tests. So all of this originated from the EU, basically, even though technically the EU does not have competence to tell member states what to do with their tax system, as long as they're complying with the fundamental freedoms, for example, and the directives are in place. So through the back door of aggressive tax planning, a political concept, the Recovery and Resilience Plan, there are demands made on the member state, on the sovereignty of a member state. The second one, which I find even more problematic, is the request to impose withholding taxes on outbound payments of interest, dividends, and royalties to low tax jurisdictions, with the option of non-deductibility. Now, it's one thing if a jurisdiction is blacklisted. However much we criticize it, you blacklist, it's there, it's been accepted by member states. There is a guidance on defensive measures, which includes withholding taxes for payments going there. So there is a little bit more of a legitimacy, if there is any, on the basis of that's what the Code of Conduct Group has agreed. Member states are in the Code of Conduct Group, so there is some sort of implied acceptance. But when it comes to just generally imposing withholding tax, jurisdictions that have low taxes, I find that is also quite sort of a stretch. And this is also demanded by the Commission, the EU, is demanding Cyprus to do that, and I assume some other member states as well, if we read the country-specific recommendations. So I find this sort of is maybe taking it a step further. However, it's already been, to the best of my knowledge, it's agreed by the government that this will be done. It will be the second milestone. And the third suggestion or recommendation was for Cyprus to assess the effectiveness of the overall set of measures related to aggressive tax planning by an independent valuation. I'm the person who is doing this independent valuation. I got a tender. I won a tender with the Ministry of Finance, and I can't really disclose much more than what the report will be out soon, but I find this quite problematic area, having to suggest changes to the corporate tax system of a country on the basis of very vague benchmarks, which are not really, which can also be accused of being very political. But it is what it is. So I think that shows how the evolution of EU tax law and how this impacts Cyprus. So even though Cyprus started off as being very compliant with everything, through soft law, which is, as I say, not legally binding, it is being forced to change a lot of its, not a lot, some of its rules, but some of these rules that really are very important for the competitiveness of the country. And it seems to be more of a political issue rather than a legalistic issue. What is at stake? What does the future hold? Well, there are a lot of proposals out there. The past few months, the Commission has been very productive. Not all of them have a very high likelihood of being adopted. Let's not forget we have elections next year in the European Union. So the focus may not be tax as it was 4 years ago. But the Commission has been working on this and has recently released from 2023, we've had quite a lot of proposals. So one is the Shell Directive, which is a step further, basically, for more reporting obligations for companies. The second is a proposal for BFIT, the Business in Europe Framework for Income Taxation. This is sort of the successor to the CCCTB, which has been ongoing for 20 years. I'll say a little bit about each of these proposals later on and whether I think they have any chance of going forward. The proposal for a transfer pricing directive, the proposal for a head office taxation directive, the proposal for a directive on faster and safer relief of excess withholding taxes, and the not yet proposed directive on securing the activity framework of tax enablers. So the Shell Directive, which I'm sure some of you probably know because it's been quite a lot of, it's very contentious, would basically imposes various gateways where companies' undertakings would need to comply to make sure they're not deemed to be shell companies, because if they are deemed to be shell companies, then they can lose their rights under the tax directives or their tax residence certificate. Now, we've had a first proposal last year, but there have been compromise texts, and from what the Commission said at various conferences in the past few months, this is likely to change further. But the idea is that companies that are involved in cross-border dealings with passive investment and they are outsourcing management control, they would need to comply with reporting obligations. And these reporting obligations would look into the premises, the employees, and bank accounts, having active bank accounts. The idea is to identify shell companies and make them lose rights under EU law. So this can be very problematic depending on what the gateways are in the end and what the criteria are. The second one, I think Shell is more likely to go forward in some shape or form because anything that has to do with disclosure has had a high chances of being implemented within the European Union. Obviously, we ran into all the other issues that Philip talked about, so it may be struck down a few years later on the basis that it doesn't comply with the Charter of Fundamental Rights and certain rights, but I think this is more likely to go ahead. Now, the BFIT, which will basically establish a common tax base plus consolidation allocation to member states. Now, this is going to be mandatory for large groups, which again are defined as groups that have combined revenue of more than 750 million. It's very problematic because it needs high level of cooperation between tax administrations. I don't think we are there yet. I don't think we are going to. I don't think anybody believes or this will go forward by next year. This is likely to take a few more years until we are at this level of integration where it's possible for tax authorities to have consolidation of a tax base and then allocation of the revenue. The draft transfer pricing directive incorporate, basically member states will be required to incorporate the answering principle into EU law. Most member states already have done that. They comply with the OECD guidelines. However, this would be an EU directive, which means taxpayers will have rights in the Court of Justice under EU law for this directive. This directive will establish a lower threshold for associate enterprises, so it will catch more dealings, be 25% rather than 50%, that is usually the case. It will also require member state tax authorities to give corresponding adjustments. So if another member state does an uplift, the other one has to do a corresponding adjustment. I think this is something that in Cyprus we don't have that many corresponding adjustments. So this is an important directive. If adopted, it will introduce a lot more compliance, perhaps. Cyprus has already, from my understanding, is already complying with the OECD guidelines to a large extent. However, all these sort of differences with the guidelines are likely to create technical issues. And the directive, the HOT directive, Head Office Taxation Directive, basically this will allow small and medium enterprise groups where you have a head office and a permanent establishment for the tax rules of the head office to basically be applicable to the permanent establishment. So this is their scope for tax competition here, because if a company decides to have its headquarters, its head office in Cyprus, then it will be the Cyprus tax rules, the P will be taxed on the basis of the Cyprus tax rules, not the tax rate. So the revenue basically will be, Cyprus will collect the revenue and give it to the member state of the PE, but the rate will be that of the PE. So this will have a scope of tax competition. There's headroom for tax competition here because jurisdictions that have very good head office taxation rules, there will be a choice, a destination for companies. I think this probably has some chances of success, especially since the BFIT, I don't think is going anywhere. So the ones to watch out, I will say, is the Transfer Pricing Directive and this directive. I think these are more likely to go forward in some shape or form. Now, the FASTER directive, basically, will be, this is for streamlining of withholding tax procedures, whether through relief at source or a refund. This is quite a good directive in a sense because it will remove some of the compliance burden and it will streamline the procedure. Cyprus doesn't have generally doesn't have withholding taxes, but as it looks like they're going to be introduced, this is going to be very good for Cyprus as well. I think also this is likely to go forward in some shape or form. I say some shape or form because usually these proposals, they're then negotiated in Council, and sometimes there are amendments to it that change them quite a lot. Sometimes if there's not that much disagreement between member states, they are adopted. So the general possible impact on Cyprus of these proposals, well, let's just talk about the one that has been adopted, the Directive on Minimum Effective Tax Rate. As I said, it's likely to be limited impact because in-scope groups are unlikely to be in Cyprus, headquartered in Cyprus. However, there might be constituent entities in Cyprus, in which case you would need to know this very, very technical piece of legislation, which is going to be adopted, not sure if it's already been adopted in Cyprus, by the end of the year. Cyprus already follows transfer pricing guidelines of the OECD, so I think there will be less of sort of transition issues if the TP directive is adopted. However, as there are differences between the guidelines and that directive, whatever it comes out of that proposal, that is likely to create sort of a two-tier rules, one for EU groups and other for groups with third country companies. And as I said, and Shell is probably going to be more problematic, increase the compliance burden for companies, but on the other hand, it could also help bring more substance in some structures and remove the temptation of using shell companies in jurisdictions if it's going to be that, if it's not going to be attractive anymore. However, what should be monitored very closely is the soft law that is coming out of the Union. the blacklist, the sanctions, all the requirements to introduce withholding taxes on the basis of a very vague concept of aggressive tax planning. And this is what my understanding is sort of being planned ahead, so withholding taxes for payments to low tax jurisdictions. It hasn't been defined what is a low tax jurisdiction, how much the withholding tax will be, but this is something that the EU is quite keen on as far as Cyprus is concerned. And just to say a few things about my personal views on the Cyprus confidential papers. These are not tax related, as you know. However, the reputational damage is huge, I think. Personally, I have publicly criticized the report on the basis that I found the writing to be very sensationalist, the way it came out. Also, the language used, I found it to be quite damaging without any substance, really. There are investigations going on for these accusations. I don't want to preempt this. However, what I do want to say is that it's very important to have adequate monitoring systems in place for the financial system and what is going on in the tax department as well, as far as taxes are concerned. From my overview of the tax system generally and how it has evolved through the years, there is largely compliance. To the best of my knowledge, there haven't been any infringement proceedings in corporate taxes or direct taxes in Cyprus that Cyprus was involved with, that the Commission sued Cyprus. The proposals tend to be adopted quite fast, efficiently implemented, and it's good to sort of have wider knowledge of this area because there are so many layers of rules and laws and principles that are affecting the country's ability to enact tax laws, basically. So this was my presentation, slightly shorter than Philip's, and we are going to be open to questions. Generally, it's more like what has been happening up until now, what is happening now, what is likely to happen in the future, and there are some personal thoughts as to whether this is the right way to go about tax reform. Thank you.
Hello. Okay. Thank you both. Very interesting information. I'm obviously here in my capacity as a business person as opposed to a tax advisor, lawyer, or chartered accountant. The information, I'm trying to digest them more in an effort to understand how all this information you've shared will help Cyprus and will help it both to, I would say, enhance its reputation as opposed to amend, because my feeling is that we are unjustifiably being targeted all the time. So I will start with Philip, and a question to Philip to sort of initiate this Q&A session. Philip, based on your experience, what advice would you give to the Cyprus government on best practices to be followed in establishing confidence and fairness towards taxpayers?
Well, the obvious thing actually is to instruct Christiana to prepare reports for the Cyprus government on the EU requirements there. I think the main thing is to keep an eye on the developments. You're not going to be one of the jurisdictions at the forefront of, for example, challenges. Though if you think about it, Luxembourg, for example, has really put itself forward as one of the jurisdictions where the courts are most frequently making references to the European Court on issues like cross-border exchange of information, on the Charter of Fundamental Rights. So I don't think Cyprus is going to be at the lead, but I think you need to keep a watch on what is happening elsewhere and not lag behind.
Thank you, Philip. Christiana, one for you now. I've been hearing you talking about new laws, new regulations. To us practitioners, that sounds very administrative and obviously causes us a lot of stress. We have to fight with clients who are quite unwilling to comply and pay, etc. To my mind, however, this sounds like a big opportunity to show that we are a credible jurisdiction and we are a very compliant one. How do you think Cyprus can utilize all these new laws? You've mentioned some ideas in your presentation, but please share a more sort of general opinion as to how Cyprus can really utilize all these new laws to its benefit and to show that it is a credible EU jurisdiction that is compliant with regulations.
Thank you. As I mentioned, the fact that there are very few, I don't think there are any infringement proceedings, correct me if I'm wrong, against Cyprus when it comes to its corporate tax system. Yes.
No state aid cases, and no state aid cases.
Yes, exactly. So that's sort of one indicator that the tax system is robust as far as compliance with EU tax law, direct tax law is concerned. There are sometimes letters sent, which is the first stage, but Cyprus quickly complies with that. So I think that's one thing that shows that, and maybe that's something that, if the government decides to do a PR thing, that, look, we haven't been attacked, we haven't been investigated by the Commission on state aid, we're doing the right things. Obviously, sometimes things may go wrong, in which case it needs to be investigation of, was this an issue of monitoring, was this an issue of monitoring of the legal profession, of the accounting profession. This is a salutary exercise that should happen in every member state. I think what needs to be done is every time there is a proposal, obviously before it's adopted, to see whether there is any scope for negotiation in Council, because Cyprus has a veto. Cyprus can veto proposals. However, Cyprus very rarely does that. There's a lot of political pressure. From my understanding, very rarely it's allowed to veto anything, which is illegal technically, but it is what it is. So I try as much as possible to influence the, maybe have coalitions with other member states to try and influence the final proposal, rather than just sit at the back and wait for all the big member states to do the job. That's one, being more proactive, and that obviously will take a lot of time to build those with other member states. The UK used to be the best one to object to proposals, basically, but now it's gone. So there's a huge vacuum left by Brexit when it comes to being obstructive. I think the Eastern member states are quite good at it, but it needs to be done more constructively, rather than on the basis of what each member state wants to gain out of this. And then when this is adopted, the government needs to look at it very carefully and see whether there's any headroom for, to be lenient within the scope of this proposal, so that Cyprus remains an attractive tax destination for companies. And there is so much compliance burden right now to focusing on substance. I think it's too much, and all this information in some member states is not really processed. I don't know how it is processed, if it's possible to process, because of the capacity limitations. So if it's complying with all the EU directives, EU regulations, I think that that is testament to being a good, sound commercial destination for companies. And so basically just keep on doing, being compliant, adopting, being proactive whenever you can, and just studying the final directive that comes out to see whether there's any legitimate headroom for allowing more competition, being more flexible. Okay, I hope this answers your question.
Do you mind if I add something completely different, actually, adding just to this? You were asking about what could Cyprus do. There's one thing that we haven't spoken about at all this evening that Cyprus could think about, and that is there's a big debate going on at the moment between the OECD and the UN. A week ago, there was a resolution passed to establish a new tax discussion basis within the UN. It was supported completely, came from the African group, supported by Africa, Asia, Latin America, but opposed by the OECD and the UN, sorry, the OECD and the EU, with the exception of Norway. Norway said, we think that this is something that we should follow. Cyprus followed the rest of the EU and the OECD, sorry, you're not an OECD country, but the rest of the EU on this and opposed the proposals. But you're very close to Africa. And this is a way of getting on the right side of the history of the future. The history of the future is not with the OECD. The history of the future is with the UN. The history of the future. That's contradiction in terms. The future is with the UN there. And you could have an opportunity to say, we actually think that this is something where we could get closer to the African countries in the same way that in the late 70s and early 80s, you got close to the Eastern European countries and you were the first country in there. Why should Norway be the only country that's breaking ranks and is supporting this proposal? You're much closer to Africa. So that's completely off-the-wall suggestion, but it's totally different.
Thank you for that. I think it's a very interesting perspective, and I hope we should pass this message to the government. So we may open the floor to the public for any additional questions.
Thank you. Thank you very much for the presentations. Professor Baker, you have gone through the presentation with all this information that governments are collecting, banks are collecting, service providers are collecting. Has there been any study to see what is the benefit versus the cost? Because there is so much cost being borne by the taxpayers, and we haven't seen or haven't been any reports to say, okay, there is something good out of this. Thank you.
There has been one very interesting study within the US government after 10 years of FATCA. And FATCA, when it was introduced, it was known that the compliance costs will be enormous and that they will be mainly pushed onto overseas banks there. There was a study from internally, I think it's either the audit office or an internal office within the US of the effect of FATCA and exactly how much tax had been collected through FATCA. And the answer was a nice round number, 0. Not a single dollar had been collected directly. Now, that's a very confusing statistic because, of course, what you can't quantify is how many US taxpayers became compliant because of this and how far being told if you open up a bank account overseas, you must declare it because of FATCA. So it's very hard, but directly collected, 0. In terms of, say, for example, my country, how far has the UK increased its tax collection as a result of the exchange of information with other countries? I would have said the answer is probably also either 0 or very little indeed, partly because the UK has not, to my own experience, been the target of much tax evasion. We already had quite good arrangements for exchange of information beforehand, and what's really impacted in the UK was the introduction of what we call DOTAS, or you would call DAC 6, which is the disclosure, the mandatory disclosure of tax avoidance schemes. That had a bigger impact than any amount of exchange of information. But you're quite right. The costs of compliance and the costs that have been pushed on banks and the potential risks to banks, because when I'm talking about a challenge to AEOI being successful, the next stage after that is the clients who turn around to the banks and say, you've been exchanging information in connection with a system that was from day one warned to be incompatible with the data protection rules. I want compensation. I'm glad I'm not a banker, and none of my kids are becoming bankers.
Actually, if I may also, sorry. If I may just add something here in respect to banks. We're obviously bombarded by information required by banks, and I think in Cyprus they tend to be over-compliant. Having listened to what you shared with us earlier on, to me it looks as if they are putting themselves at a much higher risk with all the additional information that they are gathering because of over-compliance. And I refer to especially KYC, know your client, UBO, etc. How do you feel about that?
Well, as somebody who found that one of my French banks closed my account on me because of they didn't feel that they could adequately check the information, I feel very aggrieved about this. It wasn't difficult to open up another bank account there, but I think banks are really treading a very difficult route. You will know that with regard to accidental Americans, there were banks in other parts of Europe that closed the accounts of Americans and then were then ordered to reopen them because this was discriminatory against Americans. But the bank risks the potential penalties if they are not properly complying with CRS. I don't know, you probably know more about Cypriot banks than me, or...
No, I think Nadia knows a bit more, but generally the EU is following what the OECD is doing, and everything tends to be like gold-plated, whatever the OECD. There's stricter rules that the EU, and the EU has recently also introduced automatic exchange of information for cryptocurrencies, so that as well as for platforms. I think that's also under the OECD there are model rules. So what is happening in the EU, there are model rules at the OECD that countries can follow, and the EU brings it in and introduces it as law. So that obviously increases the obligations of member states, of taxpayers, and I think reduces the overall competitiveness of the EU. So there's sort of a lot of debate as to whether the EU is just going sort of too far the other side, and it's affecting the competitiveness of the union as a whole. So I think we're likely to see that, like some point where there will be a lot of attacks coming in by very resourceful taxpayers using things like the fundamental rights, for example, and there will likely be sort of a U-turn in all of this. But I think we're still sort of, there's some way ahead, unfortunately.
Okay, actually I have two questions, if you allow me, please. The first one is if in the context of this data protection framework that you have described earlier, can the taxpayer challenge the decisions of the tax authorities if those decisions are based on data that was illegally and unethically leaked from various personal, certainly non-governmental databases? This is the first question. And the second question, if I understood earlier from your speech, you said that under the Charter, the income tax law in Cyprus cannot be challenged. However, the VAT law, which effectively is a result of an endorsement of EU directives, can be challenged, if I understood correct. And my question is, what about the legislative clauses in the income tax law, which are themselves a result of endorsing directives, EU directives? Thank you.
Okay, shall I answer your first question, and then I think possibly the second question, I'll just clarify it and then pass it to Christiana. On the first point, can a taxpayer challenge a tax assessment on the basis that it was reliant upon unlawfully obtained information? There have been a couple of cases where taxpayers have tried to challenge that before the court in Strasbourg, and they've been unsuccessful. It's part of a broader rule that the court in Strasbourg has accepted that generally in criminal matters, if a police authority has obtained unlawful evidence, they may still use that. Evidence, even if it's unlawfully obtained, is still evidence, and they apply that to tax matters. So, for example, there was a case from Germany. You remember there was a lot of data that was stolen from LFT, the Treuhand in Liechtenstein, bought by the German Secret Service, used by the German authorities to open up inquiries into some German taxpayers. One of these German taxpayers went to Strasbourg and said, you should not be taxing me on the basis of illegally obtained evidence that we know was stolen. And the European Court said, no, that's not a breach of your right to privacy. On the point about income tax versus VAT, the point, I think you've got the point correctly. VAT, Cypriot VAT is implementing the VAT directive, and therefore it comes within the scope of the Charter of Fundamental Rights. Generally, with regard to income tax, it's a national law matter and not implementing EU. But you're absolutely right in your latter part of the question. What about those parts of the income tax code that are implementing EU requirements like, for example, ATAD? And on that, I'll pass to Christiana.
I think the answer is yes, of course, they can be challenged. And this is very interesting because the new directive of minimum effective tax rate, which requires sort of a lot of extraterritorial taxation, dispute resolution in that directive has been challenged in that it's not adequate. So there are already arguments being made that when that comes in, that directive is adopted, not just in Cyprus, everywhere in the European Union. If there is not sufficient dispute resolution provided for taxpayers to avoid double taxation, you could say this is a breach of the right to access, to have fair trial, to access justice and all of that. So there's a lot of, part of the reason why the firm recommended we have this seminar is because this is actually quite an important area that is growing, and it's all permissive. It's not just something, sort of a niche area for tax lawyers. Is actually going to affect a lot of tax laws in general. And also Cyprus, as far as I know, it is a member of the European Convention of Human Rights, so they can always use the convention, which is there's a very strong jurisprudence there. So yes, I think that in drafting all of this, rules, regulations, there needs to be, apart from compatibility with fundamental freedoms, I think now it needs to be checked compatibility with fundamental rights. One example is the attorney-client privilege, which as a result of DAG 6, it was criticized for being breached. And there was a case in the Court of Justice on the basis of fundamental rights, and they said, yes, the DAG 6 needs to change effectively. And Cyprus has adopted DAG 6, so Cyprus technically has to follow what the court has said from the moment the case came out. It cannot wait until DAG 8 is adopted, implemented domestically, that will change DAG 6. So there are all these layers of laws that are directly effective, very important laws, and it's important to know them, to know how they affect taxpayers. So, yeah.
Just following up briefly on that point, on legal professional privilege or attorney-client privilege, there is a case pending before the European Court. Again, it's from Luxembourg. Luxembourg is very active, and it involves a law firm that provided corporate advice, company law advice, rather than tax advice. The Spanish tax authorities have asked for information from the Luxembourg authorities about the advice that was given. The lawyers have said, no, legal professional privilege. The Luxembourg authorities said, that privilege only applies to tax advice. You weren't giving tax advice, you were giving corporate advice. I mean, it sounds a bananas argument to me, quite frankly, there. Why should tax advice be protected and not corporate advice? That's going to the European Court. That's going to have an impact on the extent of legal professional privilege all around Europe, in that it will be clear that it extends to advice given by a lawyer, for example, to a corporate service provider about Cypriot corporate law. So it's a case to watch.
I have two questions. One to Philip. We saw in certain fraud cases, corporate fraud cases in America, where a defense was raised that I acted on legal advice. How would that wash in the European context? The first one. And then the second question to Christiana is, with the head office taxation directive, does that relate to head office, to businesses that have head offices and PEs in Europe, or will that extend to businesses that have a head office in Cyprus, PEs in Europe and outside Europe?
The first question, I was actually on my lawyer's advice. I don't think that will help you very much, particularly if the lawyer is standing in the dock next to you. But it may be relevant to the penalty. I mean, for example, in tax matters in the UK, for example, I don't know what the practice is in Cyprus, but very often people get advice from lawyers. People get advice from me as counsel in order to put it into their fireproof safe, because it's generally has been the practice of the revenue not to seek penalties or to substantially reduce penalties if you've acted on counsel's advice. But I don't think it would be a sufficient defense to say, I'm being charged with murder of my spouse. I did it on my lawyer's advice. There. It's not going to go very far.
I was speaking in the context of tax.
I thought so as well, but I'd like to sort of broaden it into other areas there. Sorry, Christiana, yeah.
Sorry, the second question, it's still a proposal, so it could change. From what I remember, I think it's only for EUPs, and also there needs to be, like, the Ps, the revenue cannot be more than the head office, for example. So it needs to be, it can be used for tax planning, but not like basically just put a head office there that doesn't do anything and then have Ps and be able to use the tax laws of the head office. So there are safeguards in place to ensure it's not abused, but yes, it's a very interesting proposal. Although this proposal may change by the time it's adopted, and it might include non-EUP, so it might be more difficult to deal with that. If you're dealing with a non-EU jurisdiction, they might not accept the head office calculation of the tax base, basically. So it's more difficult to enforce it with non-EUPs.
Okay. Do you mind if I ask Christiana a question based upon that? Do you think that this HOP proposal is the first step towards a one-stop shop in Europe? I mean, it makes sense in Europe for businesses to be able to deal with one revenue authority, and then that revenue authority to sort of share the revenue with other countries. And if that's right, then there will be an element of forum shopping, and people will be looking at tax authorities and saying, which is the tax authority that is most accessible, most reasonable, most prompt, is Cyprus going to be up there for businesses in Europe saying, one of the reasons why we located our European regional holding company in Cyprus was because of all of these factors that made it attractive for us to be operating through a Cyprus holding company rather than, say, a Dutch holding company or a Luxembourg holding company.
Yes, I do think there's scope for that, definitely. And I was discussing this with Naya yesterday, and she's the one that raised the issue that this is likely to help Cyprus. So it should be closely monitored, this proposal. And in the past few years, every time there was sort of a sway of proposals that were very heavily anti-abuse, disclosure, the Commission would throw in something that would help competitiveness, like the Tax Dispute Resolution Directive, which is a directive that helps resolving tax disputes within the EU outside of treaty mechanisms. That's a very good sort of efficient way. And this is also a very good directive, a proposal. And there will be headroom for basically cashing in on the positives of the Cyprus tax system. Basically, it's efficient, the tax department as efficient as it can get and improved. So I think that's a good way, that's a good proposal, because it will be an incentive for member states to improve their tax department so that they can attract investment. I think that's a good way to attract investment rather than other ways which have been quite disastrous. So yes, there is scope for, as I was saying, you need to monitor what is happening at EU level. There are some good proposals, there are some bad proposals, and there's some that sort of a hidden, in a way, hide opportunities for the country. So yes, my answer is yes, very much so.
That's obviously too hot for Cyprus. I hope that, the colder countries accept it. Any more questions? Okay, well, thank you very much, both of you, for these excellent presentations, and thank you all for attending. It will be our pleasure to host you to a nice cocktail after the event. Thank you.